Cargill International.
May it please the Court, I appear for the appellant, my learned friend Mr. Bovensiepen, and my learned friend Mr. Young and Miss McRae appear for the respondents. The Court will be aware there are two issues on this appeal. The first issue concerns the construction of Clause 49, and the second issue, which arises if the appellants are correct on issue 1, concerns the application of that construction to the facts.
Yes, we have read your respective full and helpful cases and the two judgments below. I think it's worth mentioning that we all independently are rather surprised to see it's listed for 2 days rather than 1. We would be surprised and disappointed if it didn't finish within the day.
My Lord, that is noted. My Lord, turning first of all to issue 1.
Yes.
Issue 1 concerning the correct construction of Clause 49, and in particular of the phrase within it, the charterers and the agents, it raises an important and fundamental question for charter party construction. The reason for that is that the application of the clause in the present case is being tested in the specific context of the application of the words charterers or their agents to third parties who are in no contractual relationship with the time charterers, Transclear, a sub-charterer possibly, IBG, a receiver of goods, and as recorded in the jointly agreed formulation of issue 1 for the purposes of this appeal. For the purposes of our first inquiry, it is to be assumed that neither Transclear nor IBG were performing any relevant obligation of Cargill under its charter party with the owners. So in other words, the charters were not acting de facto or otherwise through Transclear or IBG and not through the agency of IBG or Transclear. And so the question then arises in relation to such third parties in that position, was the Court of Appeal right to hold that their acts can be treated as the acts of the charterers and their agents? The question is important because the question raised by the issue 1 concerns a phrase in general use, charterers or their agents, one in widespread use not only in time charter parties but also in voyage charter parties, and in the time charter party context with which this court is concerned, is used as a term in almost all forms of standard form time charter party, particularly the NYPE form, from which variants derive, and also in many commonly available and commonly used forms of rider, an additional clause dealing with particular subject matter, we do in this particular case, arrest and smuggling, but also in many other different contexts.
One's surprised that there isn't authority on this. Let's take a simpler case than the rather odd facts of this one. It must be quite common for receivers to arrest a ship for damage to cargo, and the receivers may, in some circumstances, have been the people who, under contractual arrangements down the chain, were responsible for discharging, or they may not have been. They may simply have been receiving it from whoever undertook and arranged the discharge. Now, on the case against you, it seems to me that logically the application of this clause should depend upon whether the receivers had a role in discharging or did not have a role in discharging. But one would have thought that on the case against you, if the receivers were simply receivers and had no such role, it's difficult to see how it could possibly be argued that when they arrested the vessel, that was an arrest occasioned by any personal act or omission or default of the charterers or their agents. And yet it's said against you that it makes all the difference if they had some role. I'd like to inquire just further, assuming that the argument against you is correct, just to test its correctness, one ought to think about what the position under the time charter is. Logically, if the argument against you is correct, time charter hire must continue to be paid, but there would then have to be, presumably, a claim by time charterers against owners saying, you have caused us to pay extra time charter hire, by damaging the cargo, leading to an arrest by a third party, and we can recover that in some way under the time charter as a breach of contract in failing to look after somebody else's cargo. Now, all this may be correct, but I'm surprised that there isn't any authority on it, because that seems to me a much more familiar situation than the one we're actually dealing with.
My Lord, yes, and of course in most standard forms of time charter party, there will be an obligation, as there is in this charter party in the printed form, clause 18, a clause which deals specifically with the obligation on the charterers. It's in the appendix, my Lord, at page 167, using the MS numbering.
Sorry,
Yes,
what?
167.
Oh,
Yes.
I've got some separate.
It's the core bundle. Yep.
Sorry, my Lord, core bundle,
Oh, right.
Yep. Clause.
clause 18.
Thank you.
Yep.
And your Lordship is right, this is a situation which would come up a lot. If one looks at clause 18, the last three lines at lines 223 to 225, charterers will not suffer nor permit to be continued any lien or encumbrance incurred by them or their agents, which might have priority over the title and interest of the owners in the vessel. And one of the points that was addressed by the appellants to the Court of Appeal was that this provision, in some respect, acts as a mirror to the off-hire provision in clause 49, and that it has never been suggested, in relation to this very well-known provision, that an arrest by the receivers, the shippers, a sub-charterer, is an arrest which the charterers are required to discharge because it is to be treated as an arrest by their agents.
Yes, and I mean, logically, on the argument against you, the charterers would simply have to bear the time charter hire and would indeed be in breach of contract themselves through allowing the arrest, which was a perfectly legitimate arrest by the receivers, if the receivers had any role in the discharging. But if they didn't, then this clause wouldn't apply, and charterers would presumably be able to point, if the receivers were pure receivers, charterers would be able to point to some breach of contract, would they, under the charter, breach of charter?
Well, my Lord, it's not even clear from the Court of Appeal's decision that the receivers would need to have been involved in the discharge at the relevant time, because the Court of Appeal's decision expands clause 49.
No, but they couldn't be agents at all if they were simple receivers. It's not. Nobody can suggest that receiving a cargo from someone who has discharged it, completing the obligations under the charter in that respect, is an agent.
No, my Lord.
They're not doing anything. They're just receiving cargo.
That's just so, my Lord. And so, my Lord, your Lordship is right that it has never been suggested, there is no authority that suggests in relation to this very well-known arrest clause that the word agents is to be given a wide meaning in the same way that the Court of Appeal and the respondents would construe it.
Yes. Well, anyway, I make the point. But if you can back up the points you've been making with any examples in the authorities, that would be interesting. But maybe that's difficult. But as a matter of general principle, I shall be interested in further submissions on that from both sides.
Yes, Lord. My Lord, the second aspect of importance in issue 1 is that the Court of Appeal has effectively approached the question of construction by reference to an assumed or presumed overarching familiar division of spheres of responsibility. And so one's back again in the territory of rainy sky and the importance of commercial considerations when construing the terms of a contract. And what is a striking feature we would submit about the Court of Appeal's decision is that the court assumed that there was a familiar division under a time charter party to which an arrest and off-hire clause should be made to fit. My Lord, in relation to issue 1, I'm going to structure our oral argument subject to any views of the court as to how issues should be addressed under 4 main headings. The first heading is the legal and commercial context in which clauses such as clause 49 are used in time charter parties. That corresponds broadly to propositions 1 and 2 in our case.
Yep.
Secondly, the legal and commercial context as to the identification of when an unconnected third party is treated as acting as the agent of the time charterer for the purposes of the charter party between owners and charterers. That corresponds with proposition 7 in our case. And I'll deal under that heading with the Court of Appeal's invocation of the concept of delegate, which played an important part in its decision. Third, I will deal with the correct construction of Clause 49 based on the language used and in the context of other Charter Party provisions. And in that context, I'll come back further to the point that my Lord Mance was putting to me earlier. And lastly, I will deal with the commercial considerations and the rational purpose contended for by the respondents. And I'll deal under that heading with the Court of Appeal's decision in the Doric Pride as of general importance and general relevance in construing the Charter Party clauses.
Thank you.
So, my Lord, taking first the commercial context as to off-hire and arrest clauses in Charter Parties, the relevant background, my Lord, is really not very much in dispute. Until relatively recently, standard forms of time Charter Party did not contain an off-hire clause specifically addressing the subject of arrest. Absent express provision, the vessel would therefore always remain on hire. But there have developed a range of clauses available to owners and charterers, which are commonly adopted, which adopt a spectrum of risk allocation in relation to arrest and the effect on the running of hire. There is no one division of responsibility. It all depends upon the clause chosen. So, my Lord, at one end, there are clauses which make arrest an off-hire event without any exception or proviso, so casting the risk entirely on the owner. And such clauses are certainly not uncommon. At the other end of the spectrum, there are clauses which provide that the vessel will only ever be off hire where the vessel is arrested, only where the claim is one against the owners themselves. So the charterer takes the risk in all other cases, save that. So it comes down, my Lord, to a simple question of risk allocation, not concerned with blame or actual responsibility, but effectively varieties of deeming provision. And my Lord, if the court could go to our case in the core volume,
Yes. Yep.
at page 57, MS 57,
Yep.
paragraph 20,
Yes.
we have set out a number of clauses
Yep.
Which illustrate that range.
Yes.
And as part of the...
Well, we see that in each case there's reference to agents with a small capital or non-capital letter.
Yes, my Lord, and also one sees that in relation to agents, the clause is sometimes expanded.
Yes.
So, for example, in the Doric Pride,
Yes.
by reference to some wider relationship. Yes. And similarly, a clause at the top of page 58, which refers to different classes of person,
Yes.
in addition to agents.
Is by reason of cargo carried, for example, in the Doric Pride.
Yes, Lord.
That would not include, or would it, cargo damage claims? It would. What would it include? The nature of the cargo carried, or what?
My Lord, primarily the nature of the cargo carried. So, for example, there is a ban on the cargo, or the cargo yes. faces particular restrictions on import, which causes delay.
Yes. Yes, and calling port of trading would be in the same line if yes, you've traded at some port which proves to be unacceptable elsewhere.
Yes. Yes. I mean, take the example in the Doric Pride of a vessel that had never called in the United States. It was a new build, and the argument was whether by calling it the United States, the special 9/11 restriction was placed on her, whether that was by reason of the port of call or whether it was by reason of the vessel. And
yes, an arrest by reason of cargo carried, I suppose, would be if you had an arrest on the basis that the last cargo carried had left some dangerous or undesirable residue. That would be.
Yes, my Lord. For example, infestation. Infestation might
Right, yes.
be a good example.
So, I mean, this tends to suggest, as is in the Doric Pride type case, that personal act or omission of default of the charterers or their agents can't have been contemplated as covering the simple damage, cargo damage claim by someone who was a receiver.
My Lord, yes. And then, my Lord, one has the wording whereby the class is expanded from the charterers to refer to subcharterers or their agents or contractors or shippers or consignees.
That's the same point.
It's the same point, but there, my Lord, the need to show agency is displaced because one can simply identify one of the specifically identified third parties, although the term agent remains in use. And, my Lord, just to update what we've said in paragraph 20, we provided a supplementary authority to the court, which I think it should be before the court. I think it was laid out on the...
Oh, it's not this thing which came grandiosely titled Supplementary Authorities Volume.
My Lord, it is a very grandiose appellation, my Lord, for what is simply a charter party clause.
Right.
But unfortunately, that is what the rules require.
Right.
And that is why it has been put in this elaborate form.
I'm
Rather
sorry.
than handed up, stapled.
Have you got a spare copy? I think I might have left it in my room.
I have.
If you could run to 2, that would be even better.
My Lord, we can hand up a non-grandiose copy. Oh, Mr. Young has a spare grandiose copy. Does any other member of the court need a...
Need might overstate the case.
So what are we looking at?
My Lord, what we're looking at here is the NYP Form 2015, which was adopted on the 15th of October of this year. And what one sees from the explanatory notes, because of the expectation of the court that we will finish today, I will leave the court to read the background. But in essence, every 5 or 6 years or so, people sit down to revise the standard form.
Yes.
And this is the latest revision of it. And they take into account standard ad hoc clauses that are floating around in the market. And what they have done in relation to clause 17, which is on page 449, in the off-hire provision, is that they, first 3 lines, unless such arrest is caused, so arrest is an off-hire event, then the proviso, unless such arrest is caused by events for which the charterers, their subcharterers, servants, agents or subcontractors are responsible. And what has been added to clause 17 are the words their subcharterers. And you will see at the bottom of the clause the note from the drafting committee, and it's just 3 lines. The exceptions to the ship being placed off hire as a result of detention now include events for which subcharters of the charterers are responsible, as the ship may be operating under sub-time charters or voyage charters during the time charter period. And so, what that shows, and what the other clauses which we have referred to in paragraph...
This is the immediate subcharterers, is it?
my Lord,
In a chain case where there are lots of subcharterers.
my Lord, that would be an interesting question of construction, but plainly we would submit, yes, it would be their subcharterers, just like it is their agents and their subcontractors. Because, my Lord, different clauses simply refer to subcharterers or the subcharterers and the subcharterers and their agents. So one has to be quite careful with how one construes these variants of clause, because parties have available to them different wordings and choose to employ different wordings, wider or narrower. And in particular, the extension of the exception beyond charterers and their agents to include enumerated third parties, sometimes the subcharterers, shippers, consignees and receivers, but sometimes only the subcharterers, so without reference to receivers, shippers and consignees, indicates, we would submit objectively, that parties have available to them different choices and that there is no reason to read in to the term agents other identifiable and identified third-party actors who are perfectly capable of being expressly referred to. And one of the difficulties with the Court of Appeal and the Respondent's approach, the Court of Appeal didn't focus on this aspect at all, is that it treats the term charterers agents as a proxy term for all that other class of persons without restriction, even when they're not expressly referred to or added by the clause. And my Lord, that is an odd result, where, for example, in a clause that refers to charters and their agents, those other classes have not been referred to. But where you have a clause which is slightly expanded, the charterers, their subcontractors, the charterers, their subcharterers or their agents, without reference to shippers, receivers and consignees, nevertheless on the Court of Appeal's construction, because they are involved in the mesh of contracts that derive from the subletting, they are to be regarded as the broader delegates of the charterers and therefore within the clause. My Lord, that background which I have just outlined to the Court has, we submit, three important consequences for the construction of Clause 49 and the correct approach. The first consequence is that it is, in our submission, wholly misplaced to propound one rational solution to arrest and its effect on the running of hire, as the respondents do and the Court of Appeal did. The premise of the Court of Appeal's approach is that the language should be approached, if not presumptively, then at least with the firm expectation that it will be taken to adopt one particular solution or match one particular model. But there are a number of perfectly rational and equally commercial solutions which are commonly adopted in the time charter party market. All risk of arrest is on the owners at one end. All risk of arrest is on the charterers, save only when it concerns the owners at the other. And all of those individual choices between those two extremes at places on the spectrum are perfectly rational and commercial for parties to agree. It's simply...
Under this clause, it may be the wording of ours is the same, or it may be slightly different because it is in actual words different. But unless such arrest is caused by events for which charterers, etc., are responsible, if there was a cargo arrest which did in fact result from owners' breach of, I suppose, the bill of lading contract, then charterers' response or answer to the suggestion that the ship remained on hire would be the arrest wasn't caused by any event for which we were responsible, it was caused by your breach of the Hague Rules or whatever scheme governed the bill of lading, wouldn't it? And it may be the same argument applies under the present clause, where you have detention or arrest occasioned by any personal act or omission or default of charterers or their agents. If there was a cargo claim which was an understandable claim, the charterers could say to the owners, this detention arrest wasn't occasioned by any personal act or omission or default or us or anyone on our side, even if that is the right test. It was occasioned by your own breach of the bill of lading.
Yes, my
failure to look after the goods properly.
Yes, my Lord. Certainly there will always be causation questions.
I see, that's what you mean by the causation questions.
It is, my Lord, because at the moment we're only identifying who are the relevant agents for the purposes of the clause, but of course there will always be a factual question about whether there has been an act by that agent was actually the cause of the delay.
Yep. And also there may be questions about what is meant by loss of time in the event of loss of time from.
Yes, my Lord. That was dealt with by the arbitrators, and it was held that this was not a net loss of hire, net loss of time clause. So our particular facts dealing with clause 49 don't give rise to that issue.
Yes.
So, my Lord, that's the first important consequence, is that it is difficult, therefore, to say, well, one would expect clause 49 to correspond to one familiar overarching division of responsibility. There isn't one.
Yes.
My Lord, the second important aspect is to focus upon the liberty to sublet. which is heavily relied upon by the respondents as being germane to the construction of Clause 49. The liberty to sublet is found in our Charter Party at page 164.
Thank you.
The core
Clause.
lines 31 to 33, the first page of the
Yes,
Charter
I see.
Party.
Yes, I see. So general liberty plus remainder of responsibility.
Yes, my Lord. I mean, it is absolutely a trite clause
Yes.
in any time Charter Party.
Yes.
And so it is against that trite background that the parties are dealing with the sorts of clauses we've just been looking at, namely allocating risk
Yes.
at some point on the spectrum. And it does not tell one anything about the meaning of Clause 49 to say, oh, look, the charterers are entitled to sublet the vessel, but they remain responsible for the fulfilment of this charter. Of course they do. That is the position under any time Charter Party. And in those circumstances, the only question is, in relation to an arrest or an off-hire clause, having that in mind, which must be, as it were, a constant, where have the parties chosen to fix the allocation of the risk? For example, there is a clause, which we've seen, which says that all arrests will make the vessel off-hire. That doesn't take any colour from the Charter's liberty to sublet, nor, similarly, there's a clause which has an exception to that, which says save where, ... That exception and proviso does not take its colour either from the liberty to sublet. It is entirely neutral and tells one nothing. The argument that effectively one has to look at arrest and off-hire clauses as some sort of quid pro quo for the liberty to sublet. So if you have this very generous liberty to sublet and can bring other people into the picture by subletting, it's right, isn't it, that you should bear any arrests which are caused by them or arise from them is really, in our submission, misplaced.
Do you get any assistance from the words charterers shall remain responsible for the fulfilment of this charter? That might be said to indicate that what charterers are responsible for if they sublet, if they employ what might be called agents, is the fulfilment of this charter, not other obligations. Or I think that's part of your argument, isn't it?
It is part of our argument, my Lord. I'll come back to those words in another context, but those words emphasise, as it were, the non-delegability of the Charter's obligations.
Yes.
And therefore, where the Charter acts through a third party, either appointed or de facto, and that third party is performing the Charter Party or is performing an obligation upon which the Charter relies, upon which performance the Charter relies to say, I am performing the Charter Party obligation, then that is precisely the class of aid.
It doesn't prevent delegation of the function, it simply prevents delegation of the liability in a way which enables the charterer to extract himself from it.
Just so, my Lord.
In fact, it assumes that the function will be delegated, which is why such a clause is necessary.
Yes, my Lord. When we say non-delegable, we say in the sense that the Charterer cannot say, oh, but I left it to somebody else to do, you can't bring that back to me. The obligation remains the Charterer's. If the Charterer relies upon somebody else to do it, then the Charterer is responsible for that person's way of doing it. So, my Lord, the liberty to sublet tells one in our submission nothing as to the width of the clause as the respondents submit. The third consequence, my Lord, is that there is no commercial objective justification, therefore, for treating the term agent in the phrase charterers or their agents as objectively intended to stand as a proxy term for a multitude of different descriptions of commonly encountered third parties in Charter Party life. Given that the parties can choose, for example, between the clause we have in this case, Clause 49, and wider expressions such as the clause in the new NYP form or the clauses which we've set out in paragraph 20 of our case, in our submission objectively, the ordinary reader approaching this clause, knowing of the existence of all of the other clauses that can be chosen, would not naturally assume that the word agents used on its own is wide enough to cover all of those other persons.
It's a rather circular argument, isn't it? It depends on what one would reasonably suppose the Charter Party he actually entered into to mean.
My Lord, that is true.
You're assuming in your favour that it means that it has a narrow meaning.
My Lord, I entirely accept that. But if one takes two charter parties in identical form, with clause 49 which says charterers or their agents, and clause 49 which says charterers or their agents, or subcharterers or subcontractors or receivers, consignees or shippers, the ordinary reader of those two charter parties would not assume that they meant the same thing.
Well, I'm not sure about that.
They may do, my Lord. I mean, it may be that agents encompasses all of those people.
That's in practice not how charter parties are negotiated. Somebody will propose a particular form, and you then proceed on that form, possibly making amendments to it if you don't like bits of it. But the idea that people actually have in mind all the various different clauses, standard clauses that they could produce, is, I think, a little far-fetched.
Well, my Lord, at the moment we're not talking about standard clauses, we're talking about ad hoc riders to the standard form. And what we've seen are, I mean, I've taken you to the NYP form to show how standard form has just been amended to deal with that. But the examples we give in paragraph 20 of our case, and for example considered in the Doric Pride and other cases, are all ad hoc riders added to the time charter party. And in those circumstances, the parties are addressing themselves. For example, my Lord, clause 49 was expanded in the Doric Pride to add by reason of cargo carried or ports called at, an ad hoc addition. And one can, I think, objectively assume that the parties, when expanding the phrase or adding phrases to it, were intending to expand the scope of the clause. One can't, of course, take it too far, but nevertheless, my Lord, one shouldn't assume if one has the phrase agents, subcontractors, subcharters, shippers, receivers, and one crosses all that out, they mean precisely the same thing.
Yep.
My Lord, that was my first heading.
Thank you.
And so one starts against the background of this variety of possible clauses and possible wordings.
Yeah.
My Lord, the second heading was to consider the concept of a third party as an agent of the Charterer for the purposes of the Charter Party. And this touches upon the use that the Court of Appeal made of the term delegate in its reasoning to expand and develop the scope of Clause 49. As we've just been considering in the context of the liberty to sublet, the Time Charter Party undertakes certain obligations which it remains at all times responsible for the due fulfilment of. But it's commonplace in the Time Charter Party market under the liberty to sublet that the vessel is sublet once at least, possibly many times. Sometimes on time charter terms, sometimes on time charter trip terms, sometimes on voyage terms. In such a case, the charterer is necessarily obliged to perform one or more of its obligations through another person's acts, and that person's acts will be the performance of its obligations under the Time Charter Party. And so the acts of the other in performing that obligation in the factual place of the charterer are treated as if done by the charterer itself through the agency of that other person. And there is, in that sense, no delegation as such in the sense of a passing on of tasks. There will actually be the performance of a task by a third party, which is regarded as the performance of the task by the charterer. The charterer takes that performance for good or ill. Where, as here, the third party, the other person who's doing the performance is a third party with whom the time charter has no direct or indirect relationship of any sort, then the third party's performance of the time charter's obligation is treated as the charter's performance of it, and for those very limited purposes only, the third party is described in the cases as being the charterer's agent in the sense of the agent for the purposes of the charter party. Some cases also refer to that as delegate, although they put a slight health warning on the use of the word delegate for obvious reasons. And my Lord, the Court of Appeal in our respectful submission lost sight of that, and before taking you to the Court of Appeal's reasoning on that topic, can I take the Court to three authorities in the authorities bundle, which set out the concept of agent for the purposes of the Charter Party. The first, my lord, is a decision of the Court of Appeal in the Mediolanum, at tab 19.
Right.
My lord, that was a time charter party. The facts can be summarised very briefly as follows. There was a standard obligation of the time charter to provide and pay for fuel and to bunker the vessel, clause 2. The charters arranged for a terminal on the Panama Canal to bunker the vessel. The charterers directed the vessel to a specific bunkering place, so they ordered it to a particular place. The terminal, of its own bat and for its own reasons, directed the vessel somewhere else, and the vessel hit an uncharted obstacle, and the owners claimed the cost of repairs on the basis of the terminal, in directing it to that additional place, had acted as the charter's agent. And the relevant reasoning, we just pick up, just to help understand why the Court of Appeal says certain things that it does, pick up the award at page 139, left-hand column, paragraph 20 in the middle of the column. The charters did not give the order where to bunker, but by stemming bunkers at Las Minas, it is to be inferred that they left it to the suppliers, the refinery, to indicate the bunkering spot. The order given by the refinery to proceed to the bunkering place was impliedly within the authority conferred upon the refinery by Continental, properly acting as agents on behalf of the charterers to select the exact place for bunkering at Las Minas. And then, my lord, if one goes over to the next page, page 140, in the bottom of column 1, after referring to the classic test for a safe port in the Eastern City, Lord Justice Carr said this: viewed in this way, the order to bunker at Las Minas was an order to bunker at a safe port. Moreover, in the present case, the charterers, through Continental as their local agents, in fact ordered the vessel to a particular place in that port, which is also expressly found to be safe. It follows any liability on the part of the charterers in this case must depend on the inferences and consequences of the agency relationship between them and the refinery, on which the arbitrator's conclusion ultimately rests. Then they set out a question, and going over onto the next paragraph in column 2, this statement of principle: although in relation to the charterers, the refinery was in the position of an independent contractor, we naturally accept that for the purposes of the charterer's obligation under clause 2 of the charter party to provide the fuel, the refinery was the agent of the charterers as between the charterers and the owners. That's where that phrase first arises. The reason is that in that respect, the refinery was used by the charterers in order to perform one of the charterers' obligations under the contract. We are much more doubtful, however, whether the refinery can also properly be described as the charterer's agent for the purpose of indicating or selecting the ultimate place within the port of Las Minas to which the vessel was to proceed for bunkering. And then, my lord, if one proceeds to the bottom of the paragraph, about 10 lines up, how can Continental's authority on behalf of the charterers to select the exact place for bunkering have conferred any authority on the refinery, in particular when Continental exercised that authority by ordering the vessel to a safe and different place?
I mean, the bit you missed out is quite interesting.
Sorry, my lord.
Well, the reference to the analogy with the harbour master or port authority and the decision of Justice Robert Goff in the Isabel.
That's true, my lord, but the way in which the Court of Appeal approached it was to say the obligation on the charter to order the vessel to proceed to a particular place had actually been exercised by the charterers through their agents Continental. The only scope that the refinery had to act as agent for the charterers was to put bunkers on board the vessel. They had no authority and were not performing the obligation to direct the vessel. So the obligation is performed through the terminal, and for that purpose only, the terminal is regarded as the agent of the charterers, as between the charterers and the owners. My lord, the same theme is developed at greater length in a case which the Court of Appeal referred to in this case, and it is the Good Pal, which is at tab 12 in this bundle.
Yep.
My lord, here the facts were as follows. Again, a time charter party, carriage of part cargoes. This was a claim was made by receivers at port B for short delivery. The short delivery had come about because the receivers at port A had instructed the vessel to discharge a greater quantity at A than should have been discharged there. The owner claimed against the time charterers on the basis that the receivers at port A acted as the time charterers' agents in doing what they did. And there are two issues, therefore, in the case. The first is the identification of whether it was short delivery or the fault of the charterers or the charterers' servants, the receivers at port A. And that was a question of general application. The second issue, my lord, was how that fitted in to the then wording of the Interclub Agreement, which is an agreement for apportioning liability for cargo claims, which is bolted on to the NYP form in many cases, which used the phrase charterers, servants or agents. So the inquiry being carried out by the court was were the receivers at port A the agents of the charterers when they discharged more than they should have discharged. And my lord, if one goes to page 642 in the report, page 293 on the MS number, one sees the appellant owner's permissions in that case at the second paragraph in column 1. Mr. Geary submits that the effect of the clause is to place all responsibility for discharge, clause 8, on the charterers, since responsibility rested with the charterers. The receivers who were carrying out discharge at the first port were to be treated as the charterers' agents for carrying out that function. Consequently, if those receivers required the discharge of additional cargo, that had the effect of an instruction as to discharge by the charterers. Going down to the bottom of that column, reliance is placed upon the Arctic trader, Lord Justice Evans, where he said, it's clear in our judgment that when the time charter instructs the master pursuant to the employment provisions of clause 8 to receive certain cargo on board, the cargo is loaded at the charter expense, although under the supervision and maybe the risk of the ship owners, then the cargo is loaded by or on behalf of the charterer for the purposes of the charter party, and a third party shipper should be regarded as the charterer's agents accordingly. And it was submitted that applied equally to discharge. And then in the second column on the same page, page 642, Mr. Justice Coleman set out what he called long-established principles upon which time charterers work, just at the end of the first paragraph.
Yep.
And I'll take this as quickly as I can. He referred to the employment of the vessel under clause 8, subparagraph 1. He then refers to the fact that the charterers need not trade the vessel at all, paragraph 2. And then in paragraph 3, he says the process of loading the cargo, that will be relevant, my lord, for issue 2, the process of loading the cargo into the vessel's cargo spaces at the loading port, and the process of discharging the cargo from those cargo spaces at the discharge port are normally, but not invariably, allocated by the express terms of the time charter as one of the responsibilities of the charterer.
Yeah.
So that, my lord, is the obligation under clause 8. It is the process of loading, the carrying out of the physical operation. And that will be highly relevant for issue 2.
Yep.
Subparagraph 4 points out the shippers usually do it. And then, my lord, subparagraph 5. When the vessel is ordered by the charterers to proceed to a loading port to load a particular cargo, and the process of loading is carried out by the shippers, they are availing themselves of the facility contractually derived either directly or indirectly from the charterers of being permitted to place their cargo on board the vessel for carriage to the port of discharge. They are, in one sense, the agents quotes, of the time charterers as described in the passage cited earlier in this judgment from the Arctic trader, but only to the extent that it is to them that the charterers have delegated the process of loading. Within that limited area, their acts or omissions are, so far as the owner is concerned, the acts and omissions of the charterers, and their knowledge and condition of goods is to be imputed to the charterers. Then, my lord, I think one can go over the bill of lading points to little subparagraph 8.
Thank you.
Just as the charterer can make available to a third-party shipper the facility to load the vessel, so also there can be extended to a third-party receiver the facility to discharge the cargo at the designated discharging port. This is what happens when a bill of lading is presented by the master, presented to the master. And then, my lord, once again, the receiver is in the position of a delegate of the charterer, and in that limited sense can be described as the charterer's agent. And then, my Lord, subparagraph 9, just as the charterer is not entitled to require the master to proceed to a discharge port different from that specified in or permitted under the bill of lading, so the receiver under that contract can have no greater entitlement to redirect the master than the terms of the bill of lading and charter party permit. And just pausing there, my Lord, this will be relevant for issue 2, the match between the issues, the obligations under the charter party and what the third party is doing. And then this, in his capacity as receiver, he merely enjoys precisely that facility of discharge at the designated discharge port which the charterer himself would enjoy. And then, my Lord, going over to page 644, Mr. Justice Coleman dealt with the facts, and if we pick it up at the bottom of column 1, inasmuch as it was the receivers at the first port who purported to instruct the master what to do with the cargo destined for the second port, they were attempting to interfere with the employment of the vessel in a manner which is not only inconsistent with the charter's fulfilling instructions, but had it been authorised by the charters would have been inadmissible. They stood in the charterer's position only to the extent that they were responsible for carrying out the discharging operation at the first port, and the only permissible discharging operation was that in respect of 19,000 tonnes. Once that had been accomplished, they were no longer the delegates of the charters, and there were no longer any further orders they could properly give to the master. So, my Lord, they're focusing on the performance of the obligation under the charter party. When that obligation has been performed, the status of the third party, call it a delegate if you will, as agent of the time charter has come to an end, because the performance of the charter party obligation has come to an end, and he's only an agent for the purposes of that obligation and no further. And, my Lord, in our submission, that is the case where the word delegate comes in. Other cases refer to the charterer, third party as being the charterer's agent. This is the case where that term was expanded to refer to the term delegate. And it was delegate in that sense which the appellants below in the Court of Appeal said it had to be viewed in that way. Namely, somebody who is carrying out the obligation of the time charterers under the time charter party, agent for those purposes, for that very limited scope only, and no further.
Right.
My Lord, the last case I wanted to take the court to in relation to delegation is a voyage charter party case, and it's at tab 1. It's the decision of Mr. Justice Evans in the Adelpha. And, my Lord, this was a charter party for the carriage of cargo to Tripoli. The receivers failed to discharge the cargo there and then arrested the vessel, and the owners claimed that the receivers were to be treated as the charterer's agent. I can take the court to page 471 in the report, which sets out the submission and how it was dealt with. It's in the second column under the heading Little Roman 2, Receivers' Acts. The second submission is that the charterers are vicariously liable for the delay caused by the receivers and their various actions described above. So that is the failing to discharge at all and then arresting the vessel. The argument, in my judgment, is misconceived. The charterers, having undertaken, subject to exceptions, that the cargo will be discharged within the agreed period. Just pausing there, my Lord, this, of course, is a voyage charter. So there would be an obligation on the charterers to discharge, not like a time charter where the time charter party where the time charterer need not discharge, can simply keep the vessel sitting with cargo in it. Here there was an obligation on the voyage charter to discharge. So the charterers, having undertaken, subject to exceptions, that the cargo will be discharged within the agreed period, they will clearly be liable if this is not done, notwithstanding that the discharging operation has become the responsibility of the receiver or of some other party, and the charterer plays no part in it himself. Even if this can properly be described as delegating the charterer's contractual duty, it does not follow that the charterer becomes responsible vicariously or otherwise for the receivers and all that they do or fail to do. charterer can only be liable when there has been a failure to achieve what the charterers undertook to the ship owner would be done, i.e. under the charter party. There was, of course, a failure to discharge in the lay time, for which the charterers are liable in damages or in demurrage. The vessel was detained by her arrest and the subsequent judgment. There is no undertaking in the charter party, express or implied, that the cargo receivers will not arrest the vessel or seek to do so at the discharging port. So again, my Lord, in the different voyage charter party context, stressing the correlation between the status of the third party, here the receiver, as the charterer's agent, only when he's performing the charterer's obligation under that charter party, there an obligation actually to do discharge. My Lord, we've summarised the propositions which we say can be derived from the cases in our case at paragraph 51.
Thank you.
And that is at core volume at page 65, using the NS numbering.
Yes. 3 propositions, yep.
And those are the 3 propositions. My Lord, essentially, they can be summarised as follows. The delegate, if I was going to use that word,
Yes.
is the de facto agent of the charterer by reason of that person performing the charterer's obligations, or one of the charterer's obligations, under the time charter party in the place of the charterer.
Yeah.
There's no actual relationship between the charterer and the third party. The third party is only therefore identified with the charterer because he is in fact acting as the charterer performing some task or obligation of the charterers. The third party is only the delegate of the charterer for the purpose of the task or charter party obligation which is performed for and in the place of the charterer. And the third party is only the delegate or agent of the charterer when it is carrying out the charter party obligation and acting in the place of the charterer. So essentially, my Lord, it is a de facto agency where the factum, if I can put it that way, is the act of performance by the third party of the charterer's charter party obligation. And my Lord, one can test the position in temporal terms. Assume that the vessel is to be discharged at Port Harcourt, and IBG is the receiver under a sale contract which has nothing to do with the charter parties, is not anything, not a creature of any subletting or anything of that kind, is the intended receiver of the cargo at that port. Assume first that IBG discharges the goods in full. In those circumstances, the charterer's obligation, i.e. he carries out the cargo handling operation. In those circumstances, the charterer's obligation is performed, and upon the completion of the performance of the obligation, IBG no longer stands in any capacity to the charterer. Just as Mr. Justice Coleman said in the Good Pal, the delegation comes to an end upon the performance of the obligation, so there IBG would cease to be the agents of the charterers. If IBG were then to arrest the vessel, or to engage in some act which led to the arrest of the vessel, that would not be the act or omission of the charterer's agent, because IBG had ceased to be an agent for the purposes of the charter party by ceasing to perform the charter party obligation.
Is the test what the charterer is obliged to do, or is it what he has a right to do?
My Lord, it's certainly the former.
Why is that?
My Lord, in relation to the latter, plainly if the charterer elects to engage in a mode of optional performance which is permitted to him by the charter party, and a third party carries out that performance for him, then the same principle would apply.
It has to be in the performance of an obligation.
It has to be the performance in an obligation of the charter party, yes.
Or it could be in performance of a right, couldn't it?
No, it could be in performance of the right, but the right will usually carry with it also an obligation as to how the right should be exercised.
But I don't see that with the question whether it does or doesn't actually affects the particular argument. If the charterer has a right to procure discharge at a particular place or a range of places, and he exercises that right by making arrangements for somebody else to actually do the discharge, why does the enlarged form of agency that we're talking about not equally apply?
Well, my lord, because the only obligation on the part of the charterer is to effect the cargo handling operation involved in discharge.
Yes.
The charterer has given his order to proceed to a particular port, so the charterer has himself performed that right. Nobody else is giving an order as to where the vessel goes.
Well, you're repeating back to me the proposition that there isn't an obligation. But my question is, why does there have to be, as opposed to a right?
My lord, because, my lord, the third party will only be the agent of the charterer where carrying something out in the position of or in the place of the charterer.
Well, is that so? I mean, if there is a contractual right to procure discharge at Port Harcourt, and that right is exercised by giving the order to go to Port Harcourt and arranging for someone else to discharge, why is the vicarious performance of the exercise that the charterer has a right to require of the owner not likewise being done by his agents in the enlarged sense?
Because, my lord, it's necessary to separate out the particular stages. If the charterer gives his order, then the charterer has performed his own exercise of the right. The receiver does nothing in relation to the exercise of that right. The charterer can order the vessel to wait, to discharge, whatever he likes, and will do so himself. IBG do nothing on the part of the charterer. IBG give no direction to the vessel under the charter party. The only thing that IBG can do in the place of the charterer, therefore, is when the vessel is put into discharge by the charterer, IBG will then empty the vessel in the place of the charterer.
Yes, but I mean, is the exercise of a right to procure discharge at Port Harcourt is the performance or part of the performance of the charter party, isn't it?
My lord, it is. And indeed, this being a time charter trip, I think the destination and the
Are specified.
is specified. But my lord, in our submission, there's no exercise by the receiver. The receiver is doing nothing in the place of the charterer. The receiver is not giving any order to the vessel. The only thing that the receiver can do in the place of the charterer is actually to get the vessel out of the vessel.
So
the
anything
cargo out of the
else,
vessel.
you point out that if the discharge had completed and then there had been an arrest, how could it be said that that was an agency
Yes, my lord.
function? And you say, why should it be any different if the arrest, which has nothing to do with the discharge in a direct sense, occurs during it
Well, my lord, it would depend whether
and interrupts it?
it would depend whether the act, fault, or omission is won by the receiver acting in the performance of the charter party obligation, because then he would be the agent. But if one tests it, first of all, after discharge is complete,
Yes.
the receiver
Right.
does nothing for the
Yeah,
charter.
we've got that point. But
You
Lord-
go back to the liberty clause, I suppose, here, because the charters have the liberty to sublet the vessel. The charter is responsible for the fulfilment of the charter
Yes, my
party.
lord.
And the only logical distinction I can see between rights and obligations is if you say, well, the continuing responsibility for the fulfilment of the charter includes whoever may be the physical person whose activity relates to the fulfilment of the charter.
Including the discharge.
Yeah.
Yes.
But what is done pursuant to some sort of right but isn't fairly classifiable as fulfilment of the charter doesn't trigger the off-hire clause, because that's not being done by the putative agent in fulfilment of the charter.
Either in fulfilment of the charter or on behalf of the charterer.
So we then come back to a question is, how you define the range of activities which can fairly be classified as fulfilment of the charter.
Yes, my lord. My Lord, there are, of course, express provisions in the Charter Party dealing with directing the vessel to a particular place. The charters or their agents, as the charters or their agents may direct. It's not said that there was any exercise by IBG or Transclear of any of those rights or obligations under those other provisions.
I mean, your case is that exercising or not or breaching an obligation under some sale contract has nothing to do with fulfilment of the charter unless it bears directly on something which is provided in the charter.
That's that, absolutely, Lord, yes.
And if you fail to pay demurrage, which has nothing to do with the charter, under a sale contract, and if as a result someone takes steps against, well, supposedly against you, which have consequences for the ship, that's nothing to do with fulfilment of the charter. It's something which happens in the interests of those involved in the sale contract and is extraneous.
That's absolutely right, my Lord, yes.
If you go back to the good pal example, the short delivery, if the vessel had been carrying mixed cargo and receivers at A took off the wrong stuff, so by the time when it arrived at B, they realised, dreadful mistake, this has been taken off in the wrong way. And I suppose that would have related to the fulfilment of the charter. But on the other hand, if they simply took too much of the right stuff, then once they had taken off the right amount, thereafter anything they did was not in fulfilment of the charter. Would that be correct?
Lord, yes.
So, yes, so you I see the logic of it. It produces a slightly odd factual distinction. If you take the wrong stuff off, they're the agents. If they just take too much, they're not the agents. But that's the way it goes, you say.
Well, my Lord, one has to look at the particular scope of the obligation. So here, my Lord, take the example, we've already looked in temporal stages after the discharge is complete, the status of delegate or agent ceases. One then has to consider the position at the other end. When does the status of the third party as agent or delegate of the charterer begin? And I think it's accepted by the respondents in their case, paragraph 25, that when discharge is completed, the third party ceases to be the agent or the delegate.
Right.
Well, when the discharge of the appropriate amount is completed, you mean? So that if you're supposed to discharge 17,000 tonnes and you discharge 19,000 tonnes, I think your submission is that the function relevant to the charter party is completed at the moment when the 1,700th tonne passes the.
Yes, my Lord. It was in the good pal because the only instruction which was given to the charterer, to the receiver, who had the bill of lading, and therefore that was the instruction, was to take off 17,000 metric tonnes.
Well, I mean, I wonder whether that is necessarily correct. It may well be that taking too much is a defective way of taking the right amount, rather than something which is completely outside the scope of the relevant function.
Yes, my Lord. Well, there are questions about what is happening when the third party is actually performing the obligation of the charter party, of the charter of the charter party, and there may be interesting questions about when that actually comes to an end. But where, for example, discharge is completed, then IBG ceased to be the agent. Before discharge is commenced, i.e. the process of unloading, the physical cargo handling operation is commenced by IBG. IBG stand in no position to the charter at all. Because if performance of the obligation creates the de facto agency and the de facto delegation, then before the third party actually does anything, the third party is not an agent either. He's not an agent when he's finished it, and he's not an agent before he begins it. Take this example, which could very easily have happened in the present case. Assume the vessel arrives at Port Harcourt, is waiting at the anchorage. IBG is the intended receiver, but there are difficulties between IBG and Transclear, and Transclear gives instructions to the vessel not to discharge to IBG, but to discharge to somebody else. IBG never enters into any status with the charterers as the agent of the charterer. It can only be the agent of the charterer when it is actually, it takes upon itself the performance of the charterer's obligation, namely to get the vessel out, the cargo out of the vessel's hold, and it remains an agent of the charterer for that purpose in the course of performing that obligation, and ceases to be the charterer's agent when he has performed that obligation in the place of the charterer.
I wonder if you were right to accept the distinction which Lord Toulson found troubling. It just came in the good pal situation. Let us suppose that the receivers at the first point had gulled the master into discharging the wrong cargo to them because they rather preferred that. I would have thought that was a matter entirely between the master acting for the owners and the receivers, and it nothing to do with the charterers, and prima facie the owners through the master are just as much as at fault as the receivers are in asking. And
I would agree with that, my lord. And indeed, when one considers what has actually been, the task that has actually been entrusted to the receiver, the task that has been entrusted to the receiver is take this cargo off.
Oh, and to the master, the charter has said that you discharge cargo A at port A and cargo B at port B. If the master and the receivers at port A decide to do something different, that's a matter for them.
I think Justice Coleman would have said the same thing, because I'm looking again at the end of his judgment. It's tab 12, 295 MS. The foot of column 1 and top of column 2, I think, is entirely consistent with what Lord Mance was putting to you, that effectively he appears to be saying, well, they're only discharging the charterer's responsibility insofar as they are acting in accordance with the charterer's instructions. Insofar as they depart from the charterer's instructions, they're not acting as charterer's agent.
Yes.
Yeah.
Thank you, my lord.
Yes.
So, my lord, one has if the performance of the obligation defines the status or gives rise to the status of de facto agent or de facto delegate, and this will be, of course, relevant for issue 2, then where the acts, omissions or defaults are done by a third party before he starts the performance of the charter party obligation, they are done by a third party, just as in the same way, if they are done by the third party after the charter party obligation has been performed, they are similarly the acts of a third party and not of the agent. And my lord, in that connection, can I, with those cases in mind and the propositions which we say can be identified from them established, can I take the court to how the Court of Appeal dealt with this aspect in its judgment?
Yes. Yes.
And my lord, we can pick it up, my lord, at page 109 in the report, page 119 of the MS numbering.
Yes.
And the starting point is paragraph 30. And in the middle of the paragraph, the Lord Justice Gross says this: there was no challenge to the judge's conclusion at paragraph 19 of the judgment that agents were not to be limited to agents strictly so called. Thus, delegates, the court's emphasis, of Cargill could be its agents for the purposes of the proviso, irrespective of the precise contractual relationship. The words agents was accordingly capable of extending to subcharters, sub-subcharters, receivers. And I'll just pause there. The submission that was made was that delegates were only delegates of Cargill when they were performing a charter party obligation.
Yes, well, you made that point. You say
yes, Lord.
You said he's put it more widely.
Well, the Court of Appeal is putting it more widely.
I understand that.
Than was put. And then, my lord, as a matter of language, the proviso identified the relevant actors.
Well, we don't need to read large chunks of this.
And then, my lord, paragraph 34. The proviso says nothing expressly is restricting the acts in question to those incurring in the course of performance by the delegate to the delegated task. My lord, in our submission, that is the wrong question. the question is, what does the term agent mean, and how one is to unpack that particular term. And then when one goes over to paragraph 35, one has the reasoning of the Court of Appeal. The submission is right thus far. Subcharterers, receivers and others are not in general agents of time charterers. Now, my Lord, we would respectfully endorse that statement. They will only be agents when entrusted by time charterers with the performance of an obligation of charterers under the charter party, and then a reference to the cases we have just looked at. And my Lord, there, in our submission, the Court of Appeal could and should have stopped, because that would have been entirely sufficient for the purposes, one, of identifying who agents are for the purposes of the charter party, and two, what is the ordinary natural meaning in that context of the words agents of the charterers, or their agents. And then the error begins in the next sentence. Here, however, one says is not in dispute, agents can be read as delegates. Now, pause there, my Lord. If delegate is being used as a term to describe a third party who is entrusted with the performance of a charter party obligation, then delegate and agents are precisely the same. They are used interchangeably by Mr. Justice Coleman in the Good Pal, in just the same way in the Mediolanum. So, my Lord, effectively now what has happened is that, having defined correctly the position that subcharterers, etc., are not agents of the time charterers, and only will be when they are entrusted with the performance of an obligation, the court says, but that is not the limit of the clause. By going on to say agents can be read as delegates, the ambit of the proviso is necessarily widened. Now, my Lord, here it is not clear at all what the Court of Appeal means by delegate. It can't mean a person who has been entrusted by the performance of the charter party obligations, because it has just distinguished delegate from that case, which it has set out in the first sentence. So it must be giving a wider meaning to delegate, namely, effectively, any subcharter, receiver or consignee who happens to be involved arising out of the subletting. We'll see that in just a moment. So then the court goes on to say, many a delegate will manifestly not be an agent stricto sensu. And then
the fallacy in that is that the type of person talked about in the Mediolanum and the Good Pal are not agents stricto sensu in the Professor Reynolds sense.
Yes. So one now has effectively three distinctions being drawn by the time we've got to this sentence. We've got agents in the Mediolanum and Good Pal sense, i.e. third parties who perform a charter party obligation. We've got agents stricto sensu, those actually specifically appointed by the charters under some contract of agency. And we've got delegates who are not either of those two, but must be wider. But query what that means. And they then go on to say, if a party, e.g. a subcharterer, my Lord, just pause on the e.g. In this case, the Court of Appeal held that this clause extended not just to subcharterers, but to receivers, and ostensibly, therefore, to shippers and consignees as well. If a party is a delegate of Cargill flowing from the subletting of the vessel, so well, that appears to be the definition of delegate, somebody who flows from the subletting. It's a third party who's brought in as a result in some way of the charter having sublet and enlarged the mesh of contracts below. That party remains a delegate for the purposes of the proviso, regardless of the nature of the act or omission. Not every act or omission of the delegate will need to be in the course of the performance of the delegated task.
You say the problem is what hasn't been defined is that which is delegated.
My Lord, yes. We would submit that the only basis upon which someone can be a delegate is if something has been delegated to him to do. If a performance of a charter party obligation has been delegated to the third party, he is either a delegate for those purposes or an agent for the purposes of the time charter party for those purposes. But what the Court of Appeal has done is to decouple the concept of delegate, where it is used expressly in that way in the Good Pal, and has come up with some open-textured definition of delegate, which is wider. And the Court of Appeal has said, well, because delegate is conceded to be within the term agent, because I construe a delegate very, very widely, therefore the term agent must similarly be expanded. But, my Lord, it was never accepted by the appellants below that delegate meant anything other than a good pal delegate.
Yes, I understand.
And, my Lord, if one looks a little further in the judgment to try to see what, try to give some meaning to what the Court of Appeal has given to delegate, there are three possible places one may look. If one goes on to paragraph 40, subparagraph 2, on the same page, the Court of Appeal grappled with when somebody is not a delegate even on their case. And it said, for my part, I would leave for decision until, or if it arises, the question of whether, for example, some act, etc., of a Cargill delegate, wholly extraneous or unrelated to subletting under the Charter Party or inconsistent with its scheme, would fall outside the ambit of the carve-out. And well, that appears really to be saying that the delegate is somebody who is related to the subletting of the Charter Party, and in some way the commercial mesh of contracts under the subletting, and will only step outside that category when he really is completely outside it, whatever that means.
When he says not every act or omission will or need be in the course of performance of the delegated task, you say, well, that's certainly right, but you say that it has to fulfill two criteria. Firstly, it has to be something which the, in inverted commas, agent has been authorised to do, and secondly, it has to be in fulfilment of the Charter Party.
Yes, but it has to be something in really just applying the words which the Court of Appeal has correctly applied from the Mediolanum and the Good Pal. Only agents, when entrusted by time charters with the performance of an obligation of charterers under the Charter Party, which effectively comes to the same thing that your Lordship is putting to me.
Well, I'm not sure it does entirely, because you may be, the agent may misperform. The example we were talking about in the Good Pal, as varied, where the receiver gulls the master into offloading the wrong goods. Now, in one sense, there has been that there's a function that receiver has been given. On the other hand, he is absolutely not doing that which is authorised by the charterer.
Well, Lord, there will be questions where the act is actually one within the performance of the obligation that has been entrusted to him. So, for example, if the obligation is badly carried out, for example, the receiver discharges the vessel but damages the vessel, then that would plainly be something that the charter is responsible for, because the charter, through its agent, i.e. the person through its acting, through the agency it is acting, has damaged the vessel in the course of discharge. There may be more difficult examples depending on the particular obligation being performed. Lord, if one...
So if he negligently damages the vessel, that's one thing. If he negligently discharges a bit too much, that's the other side of the line.
Well, I mean, that would depend upon the particular instructions given. In the Good Pal, he was instructed only to discharge 17,000 tonnes. That was the instruction given to him. That was the act that he was performing in the place of the charterer. He then went beyond that and took a bit more off.
Well, I suppose if he was instructed to discharge without damaging the vessel.
My Lord, the difficulty is that, of course, one's considering different types of agent. Yeah. One will have agent stricto sensu, where there are instructions which define the scope of the authority. But here, all we are looking at is a de facto agent who is treated as an open quotes agent for the purposes of the Charter Party or delegate, simply by the fact that he takes on an obligation of the Charter under the Charter Party to perform in the place of the Charterer. My Lord, I'm just finishing off the other places where one gets some light on what the Court of Appeal might have meant by delegate. One looks in paragraph 41,
yes,
about a third of the way up from the bottom. Lord Justice Gross said, while it is correct to say that Cargill was under no obligation to discharge the vessel at any given time, the dispute in question arose out of its trading arrangement concerning the vessel. So, again, there, the approach being taken,
yes,
that it is a a subletting type matter or a trading matter. And it is important, I'll come back to Doric Pride separately
Yes.
later, but it's important that the Court of Appeal relied upon the Doric Pride, which had, as my Lord Newberger was pointing out a little earlier, a completely different provision in, which referred to by reason of cargo carried and ports called at, where, of course, the trading arrangements are specifically identified in the clause. And then, my Lord, lastly, paragraph 43(1),
Yes.
where this is the only treatment, I think, of the good pal in the context in which it was being referred to by the appellants. Lord Justice Gross deals for completeness with the cases cited, and he says the good pal concerned the apportionment of claims under the interclub agreement, not off hire under the particular clause here in question. We'll just pause there, my Lord. That in our submission is not a correct summation of the decision in the good pal, which dealt in general terms, as Mr. Justice Coleman was at pains to point out, with established position under time charter parties in relation to agency of third parties for the charterers. And, my Lord, even if it did also concern as a second aspect the interclub agreement, the words there were the same, the charterers or their agents. Why should they be given a different meaning in a bolt-on apportionment regime to the charter party than they should be given in the charter party itself? So, my Lord, we would submit that the starting point that the Court of Appeal adopted in relation to delegate was wrong, and that the Court of Appeal lost sight of the fact that delegate equals agent equals delegate. They are the same concept and the same way of expressing the same thing. It's just a different term. And the word delegate was only used by the appellants as shorthand in just the same way as Mr. Justice Coleman used it in the good pal for someone who was carrying out the obligation of the charter by performing it. My Lord, before leaving that second heading, can I then just consider what is the respondent's definition of delegate? And, my Lord, the one convenient place of picking it up is at paragraph 25 in the respondent's case, at page 92.
Yes.
And one has a similarly open textured definition as the Court of Appeal adopted. The position could, however, just as readily be that after the vessel arrives at the discharge port, she is to be discharged by whomsoever Cargill designate, and whoever Cargill do thus designate are the delegates of that function and become relevant agents of Cargill accordingly. Although the difficulty with that analysis is there is no designation by Cargill of anybody, or at least in the terms of the two actors we're talking about here, and it's not the designation by Cargill which gives rise to the status as delegate and status as agent. It is the performance by the third party in the place of Cargill of the obligation. So, Lord, one doesn't really get in our submission any real meaning given to the word delegate by the respondents, other than that given by the Court of Appeal, which is something flowing from the subletting, which is very wide.
Yes.
And, my Lord, and has within it inherent difficulties, even on the Court of Appeal's own ill-defined, expanded definition. Because if one's talking about flowing from the subletting, one can see how that might encompass at least subcharterers. But because they do flow from subletting, although only in an indirect way under each particular charter party. But it's very difficult to see how that expands to shippers, receivers and consignees.
Yes, I
Under sale contracts which have got nothing to do, sometimes completely stand apart from the chain of charter parties.
Yes.
Although that was my second heading,
Yep.
and the well-established identification of third parties as agents of the charterers. And now I come on to my third heading, which is the construction of Clause 49. And, my Lord, I was going to deal with this in three sections. First of all, the correct approach.
Yep.
Secondly, the language of Clause 49. And thirdly, the other charter party clauses.
I think you can take the correct approach very swiftly.
My Lord, I anticipated that, my Lord.
There's a lot of law on construing contracts, and
My Lord,
I think we
the court is very familiar after Arnold
take it.
Britain
Well, yes.
with all of the relevant
Yeah.
tests. My Lord,
And when you say one starts with the words and no preconceptions.
yes, my Lord.
So be it. We have that.
Thank you. And therefore, my Lord, the respondent's starting point in paragraph 22 of its case, that the meaning to be ascribed to agents depends on the purpose and context of the word, is wrong.
Yep.
The starting point is the language, and particularly, objectively, as my Lord Neuberger said in Arnold and Britain, that the parties can be treated as having addressed themselves to the problem in play, particularly, my Lord, where one has different types of charter party provision dealing with these matters, expanding the category to charterers, agents, sub-charterers, etc., or narrowing it. My Lord, if we look at the clause itself, the easiest place to find it, because it's split over a number of pages in the actual charter party, is in the appendix at page 174.
Yep. Where it's split.
Oh, that's right, that is the wrong
That's
page.
where it's split.
Page
Yeah.
46, my Lord, I apologise.
Very well. Thank you.
And my Lord,
Yep.
there are really only four short points to make. Firstly, the clause looks at the charterers themselves.
Yep.
Secondly, it looks at a class of persons who stand in a particular relationship to the charterers, their agents.
Yes.
The word "their" is important.
Understand.
Just as it would be if it said their subcontractors. That denotes a specific link between the charterers and the class of persons described as agents. Thirdly, my Lord, the word agents is a word with a clear ordinary linguistic meaning. It's not a difficult, obscure or unusual term. It has an ordinary meaning of a person who acts on behalf of another, or a person through whose agency that other acts. And that, my Lord, signifies precisely either somebody appointed by the agent, by the charter to act as its agent, or a third party who is carrying out performance on behalf of the charterer, through whose agency the charterer acts. And really the point doesn't bear very much more elaboration than that.
Right.
My Lord, fourthly, one has the word personal. The clause is focusing upon the personal act or omission of the charterers or their agents. That, my Lord, at least underlines, we would submit, the fact that one is looking at the charterers and the persons connected with the charterers, not a wider class of third parties. It's focusing on the charterers themselves and those through whom they act. My Lord, that is a construction which gives a sensible and ordinary natural meaning to the term, fits in precisely with the well-established cases which deal with third parties acting as agents for the purposes of the charterer as between agents and charterers.
What is a non-personal act or omission? I don't actually understand what personal means in this context.
My Lord, it's a difficult term, my Lord, because it can't actually be like
Can't be like actual fault or privity.
actual fault or privity, my Lord. Yes.
Right.
So it can't be looking at the alter ego of the person. So my Lord, we would submit that if one's giving meaning to it at all, it's not addressing particular actors within the charterers or the agents, but it is actually saying it's got to be done. The vessel will be off hire in the case of arrest, save in one case and one case only, where you, the charterers, are personally at fault, i.e. personally in your own person, or personally to those who actually carry out things for you, but not otherwise.
Yes.
So actually, my Lord,
It doesn't really mean anything, does it? I mean,
It seems to have been common ground below that it meant, if not nothing, then next to nothing, because as I understand it, it was conceded that if the rest of the phrase, words in the rest of the phrase were satisfied, then it was necessarily personal.
My Lord, yes.
On that footing, personal adds nothing.
It doesn't, my Lord, but your Lordship is quite right that if one crossed out the word personal, the clause would mean in our case precisely the same.
the argument would be the same. Right?
The argument would be the same. But my
I think
Lord,
it's true on both sides. Yes.
if one's looking at an ad hoc charter party provision in standard use, we would submit the personal adjective emphasises that one's looking at the charterers.
Okay.
But I mean, that's a point of first impression.
Or not, as the case may be.
Or not.
But, I mean, you
Personal governance agents as well.
You accept that as regards the charterers, this is a point put against you, you accept that as regards the charterers, it wouldn't matter whether they were acting in the performance of the charter or not, I suppose, would it? I mean, if for example, well, it's difficult to think of examples, perhaps, but if they committed some default which had nothing to do with this charter, and in some curious way it really did occasion an arrest, you wouldn't seek to argue that the proviso didn't apply because it wasn't in the performance of some charter obligation or option, or would you?
No, my lord, we wouldn't, because, my lord, the question is there an act?
Yes.
Who was it by? It was by the charterers.
Yeah.
Is there an act? Who was it by? Was it by your agent? No, it was by somebody who was a third party who either had ceased to be my agent or had not yet become my agent.
You say there is inherent in the word agent a limitation.
Yes.
That the agent must be acting as the agent.
Yes.
And it's not enough if they're doing something different.
Or if they haven't yet been taken on that status.
Haven't taken it on or completed it.
Have completed it, yes, my lord.
Yes, whereas charters, inherently, you're just looking at a person.
Yes.
Yes.
My lord, the Court of Appeal, in rejecting that consideration, that construction, said that the appellants were effectively seeking to read words into the clause, but, my lord, that in our submission is incorrect, because all one's doing is unpacking what the term agents mean. They've unpacked it as mean including delegates flowing from the subletting. We've unpacked it in the same way that Mr. Justice Coleman would have unpacked it in the Good Pal. And the only question is whose expanded definition of agents is correct, and we would submit that the Court of Appeals is not. And, my lord, if one's looking at the particular classes of person who are said to be within the term agents, in our submission it's striking that it wouldn't, as a matter of ordinary language, strike the ordinary reader of this clause that it included sub-charterers, shippers, receivers and consignees, who are third parties who may have nothing to do with the charterers at all, and may even never have to perform an obligation on the part of the charterers, but who are delegates by virtue of the subletting. My lord, I dealt with how the Court of Appeal defined the word agent, which was in paragraph 35 of the judgment, which we considered in detail. I won't go back over that.
No.
My lord, can I just point out where we find some form of definition of the term agent in the respondent's case? And if I can just take a number of paragraphs.
Yes.
Paragraph 30 is where in our submission the respondents go wrong. It's page 94 of the electronic bundle.
Yes.
And the phrase charters or their agents is a perfectly normal expression to encompass what might at first blush at least presumably be the charterer's interests. My lord, and then, my lord, it goes on to say others may be instrumental, the bottom of the paragraph, in the trading and employment of the vessel. So, my lord, that is a wide submission effectively based on subletting, which we say receives nothing from the language. Then, my lord, paragraph 31, over the page 95 at the top, a general intention to apply what might be regarded by businessmen as an owner-charterer split. That again is some sort of open textured definition. And then, my lord, at paragraph 46, page 100 of the bundle.
Yeah.
Persons who are fairly assimilable to the instant charterers through the subletting of the vessel's services. And, my lord, again, even if that were right in itself, which it's not, it doesn't explain the receivers, shippers and consignees, who have nothing to do with subletting and not in the scheme of subletting.
Yes, we have that.
Contracts which are apart.
We have that.
My lord, The only other words I need to focus on before I turn to the other Charter Party clauses are the words act, omission or default. And as I have just put in answer to a point put to me by my Lord Mance, it doesn't matter what there is no attempt by the appellants to redefine the concept of act, omission or default. It is effectively a two-stage inquiry. You look at the act, omission or default relied upon. You ask whether it was an act of the charterers or an act of the agents, properly defined. You're not reading anything in to act, omission or default. And the Charter Court of Appeal seemed to think that it was necessary to read something in to the words act, omission or default, and it isn't.
Yep.
My Lord, the other provisions of the Charter Party.
Yep.
Last section in this, under this heading.
Yes.
My Lord, the expression charters or their agents, as I've already submitted, is a very common one and is used in numerous places in this Charter Party.
Yes, Lord Justice Gross sets them out, doesn't he?
Lord Justice Gross sets them out. My Lord, we've
Well, at least
listed.
he identifies the paragraphs.
We've listed them in our case. I'm not going to take
But you've listed them too, yeah.
paragraph 77. Is
Thank you.
all the examples.
Yes, I think there are more than he mentioned, yeah.
There are more than he mentioned, my
Yep.
Lord. And of course, a Charter Party, anybody familiar with a Charter Party knows that it's an agglomeration of clauses, and it's sometimes difficult to make it yield a coherent whole. But, my Lord, we would submit that if one looks at the clauses as a whole, two things are clear. In the other clauses, the term agents cannot, consistent with language and context, be read as encompassing the class of persons arrived at by the Court of Appeal. So it is very difficult to work one's way through the Charter Party, and I don't have time now to do it. But if one was to work one's way through the Charter Party clause by clause and ask whether you could put in delegates flowing from the subletting in the context of the word agents where used in those other provisions, that is a very difficult task, if not impossible. The other thing which is clear from the usages of the phrase elsewhere in the Charter Party is that the term agents, again, naturally and obviously connotes persons who are acting on behalf of the charterers or through whom the charterer is in fact acting in a particular respect. If that is right, my Lord, as we say it is, then it would suggest that the construction which the Court of Appeal adopts is completely at odds with the sense of the phrase wherever else it is used in the Charter Party.
What you're saying is that the 2 points are sort of mirror images of each other, or opposite sides of the same coin. First of all, that agents is used in a limited sense elsewhere. Secondly, it's therefore inconsistent with the interpretation which the Court of Appeal gives it in clause 49.
Yes, my Lord. We wouldn't say it was used in a limited sense. We would say it was used in its natural sense of somebody through.
Fair enough.
Because instantly, when one looks at the other Charter Party provisions, you can identify what agents means. It means either an appointed agent or somebody through whom the charterers are
Acting.
Oh,
Yes, I see.
my Lord, there are some contexts where the term agent plainly is limited to an appointed agent, clauses 42 and 74, where, for example, the charterer has to appoint an agent at a port of call, or where the charterer's agent will have to take over what the owner's agent has to do, for example, repatriation.
Yes,
So
I see.
it can sometimes be read narrower as referring to a contractually appointed agent, but in our submission it cannot be read wider.
To put your point at its lowest, you don't get any, the Court of Appeal's conclusion doesn't get any assistance from the other clauses because they're not entirely consistent in each case as to what's meant by agents, but you get assistance, you say, because it's always otherwise used in the, you would say, natural, i.e. narrower than the Court of Appeal sense.
Yes, my Lord.
Yeah.
My Lord, there are two particular provisions which I need to focus
Yes, of
on.
course.
The first is Clause 18, which we've looked at in the opening
Yes.
of the argument. And that, my Lord, is the arrest provision.
Yes, we looked at that, you're right, yes.
And my Lord, the Court of Appeal didn't grapple with this provision at all, but one sees that effectively it is if not a mirror provision, at least it's a pendant provision together with Clause 49. Clause 49 deals with the effect of arrest on the running of hire and uses the term charterers or their agents. Clause 18 deals with arrests and the obligation to free the vessel from arrest by the position of security, where the arrest is incurred, i.e. caused by, the charterers or their agents. And my Lord, in our submission, it would be very odd if the wording in Clause 18 were to be given the same meaning as in Clause 49, which the Court of Appeal has given it. Clause 18 has never been construed, my Lord, as extending beyond agents of the charterers. There's very little authority on Clause 18, but no one has ever suggested in any reported case, and indeed NYK did not suggest on the facts of this case, when the vessel was first arrested, that because the arrests were by receivers or sub-charterers, those persons were agents of the charterers, and that was an arrest which the charterers were themselves required to discharge because it was an arrest by, or had been allowed to be incurred by, them or their agents. Yes. And well, that would be a very far-reaching construction because it would allow, for example, this example to take place. The receivers arrest the vessel for a claim against the owners. The owners say the claim is entirely spurious. On this reading, Clause 18 would be engaged because there would be an arrest incurred by the charterers or their agents, the receivers. So the charterers would be responsible for dealing with the matter, even though the claim is against the owners. And the owners would be able to say, well, the claim is spurious, it's an act, omission or default of the receivers, and the vessel is off hire. Well, that is a perfectly possible situation to arrive at by drafting of a clause if one wants to expand the class of person, but it is a very unlikely result.
Would charterers, an arrest against a ship would normally be dealt with by the owner, would be dealt with by the owner's P&I club,
yes.
But charterers wouldn't necessarily have any cover of that sort.
No, Lord. But it would therefore be possible to say charterers will not suffer any lien or encumbrance incurred by them or their agents. And agents either has to mean, in the context of arrest, two completely different things, Clause 18, Clause 49, or the same in Clause 18 as it does in Clause 49. And the respondents are not afraid of that and say that it must mean the same in Clause 18 as it does in Clause 49, but that would be, in our submission, extraordinary construction. And one which is very unlikely to have escaped generations of maritime lawyers since 1946 form first came into operation.
Yes.
My Lord, for your Lordship's note, because I don't have time to take your Lordship to it, I'm aiming to complete by the short adjournment.
Good luck.
Good luck, yeah, thank you, Lord. The two cases, my Lord, on charters or their agents in this context are the Vestland, tab 25.
Thank you.
Page 182 in the report.
Yep.
And the Jalaguri at first instance, where Mr. Justice Ricks sheds useful light on what is meant by the scope of this clause. Tab 16, page 909.
That's very helpful, thank you.
So that's, my Lord...
Their authority for what?
My Lord,
For how Clause 18 works? Or?
yes, my Lord, their authority for how Clause 18 works. And there's no suggestion in those authorities that the term charters or their agents extends any further than a very close relationship between the charters and the particular agent. Certainly not that it's a wide, open-ended construction as found by the Court of Appeal. And, my Lord, the Court of Appeal simply don't address that at all. They say they just...
So, in effect, you're saying, at least on this clause, the boot's on the other foot.
Yes.
Either it is to be construed consistently, as the Court of Appeal says, in which case you succeed, or it isn't, in which case the other provisions aren't useful.
Yes, but the difficulty is the Court of Appeal hasn't said what its view is.
Quite.
Because it has, in our submission, ducked the question, but it's not a question that can be ducked because these provisions go to deal with the same event, arrest, and involves charters or their agents in the same way. And the other provision I need to take you to is Clause 50.
Yes.
I can ask you to turn on to page 175.
Thank you.
Sorry, what was the reference again?
Page 175 in the bundle, Clause 50, my Lord.
Again, yes, you mentioned
Smuggling.
Smuggling clause, yes, my Lord.
Yes.
And, my Lord, the Court...
This was Lady Justice Gloucester's point.
This is Lady Justice Gloucester's point, my Lord, which the respondents now fasten themselves to. And, my Lord...
Sorry, what tab are we?
Clause 50...
We're in the...
Core bundle, page 175.
So sorry, my Lord. Core bundle, my Lord, in the appendix, page 175 of the MS number.
underneath.
My Lord, smuggling clauses, like off-hire and arrest clauses, come in different shapes and forms and allocate risk sometimes on a very automatic basis. For example, any smuggling due to the cargo is down to the charters, all else for the owners. So again, one can't start looking for some notional allocation of risk or overarching familiar division, because there isn't one. My Lord, if this court is really required to construe Clause 50, our starting point, my Lord, is as follows. If you look at the words, if caused by officers or crew, that's on one side of the line.
Yes.
Or, for the charter's account, if caused by the charter's supercargo, staff or agents on the other side of the line, one's looking at particular individual people who are under the personal control of each party.
Well, it's hard to imagine in the context of smuggling how, on any view, things that anyone else would be relevant.
My Lord, yes. Well, we entirely agree, my
But I
Lord.
mean, it's a totally different context.
It is a totally different context, my Lord.
Smuggling is not a mode of performing the contract.
No, my Lord. Your Lordship is right, my Lord. And also here, my Lord, one has very different wording, which is why the Court of Appeal went wrong in our submission in relying upon it. One has supercargo, not a gentleman one often encounters these days, but the person who the charters have the right to put on board the vessel during the charter party. Their staff, i.e. the actual employees of the charters, or their agents. And there, my Lord, if ever agents were to be construed as being the appointed agents, for example, at the port, as under Clause 42 and Clause 74, that would be one good instance of it. So that our submission is the correct reading of Clause 50. But if we're wrong about that, my Lord, and one has to go on and expand it, then, my Lord, it can be given sense if you use agents in the same way as a good pal agent, Mr. Justice Coleman agent, i.e. agent for the purposes of the charter party. So if one takes the receivers as an example, after the receivers have discharged the vessel, they row out to the anchorage and put something on the hull of the vessel. The act then is not done by any receiver as agent of the charterers. Assume that before the vessel arrives, or while she's in anchorage, before she comes into berth to perform the cargo operation, so before the discharge operation has been commenced by the receivers, some employee of the receivers brings something down to the port in preparation for smuggling. That would not be an act done by the receivers as the agents of the charterers. It would only be while the receivers are performing the discharge operation and drugs would be taken on board or contraband taken on board that the clause would work in that way. But for the reasons given by my Lord Sumption a moment ago, even that is an unrealistic expansion of the clause. The clause is dealing with the personal officers or personal appointees of the charterers on both sides of the line, officers and crew, supercargo staff and agents. And what in our submission cannot be the sensible reading of the Court of Appeal, which appears to have been the reading which the Court of Appeal adopted, is to say that it means any delegate flowing from the subletting. That would mean that any subcharterer, any shipper, any receiver, any consignee would be regarded as the delegate of the charterer, simply by virtue of the subletting and the mesh of contracts that the charterer has given rise to by his subletting. That would be an impossibly wide construction of Clause 50 in our submission. And so when the Court of Appeal rely upon that in some ways supporting the construction of Clause 49, they were wrong to do so. And my Lord, also in a way it is a slightly dogged approach, because if all the rest of the clauses of the Charter Party go in one direction to deal with agents in the normal way, if Clause 18, which deals with the rest, can only really sensibly be interpreted in that way, then why should one get a key to construing Clause 49 from Clause 50, which is dealing with something completely different? Smuggling. It's got nothing to do with any performance of any obligation. My Lord, the last provision which the Court of Appeal relied upon was Clause 66. And that's at page 177 in the MS numbering in the appendix. And well, this is entirely neutral. The Court of Appeal said it would be a very odd result, wouldn't it, if, because of an arrest of a vessel by Transclear and IBG, putting the vessel off hire, the charters would have a right to cancel the charter party after 30 days. But, my Lord, if one looks at Clause 66, that is a provision sometimes found, sometimes for a different period, sometimes not found at all, where the owners and charters have agreed that if there is an off-hire event truly so-called, which lasts for 30 days, then the charter party can be cancelled. It's very difficult to see what assistance one gets from Clause 66 as to the correct construction of Clause 49, or indeed any other phrase in the off-hire provisions of the charter party.
The Court of Appeal's approach must suggest that the parties connected Clause 49 and Clause 46 when they were devising this wording, doesn't it? And the reality is Clause 66 belongs with Clause 15.
Yes, my Lord.
That's what they will have had in mind.
Yes. So Clause 66 gives no assistance. So, my Lord, for those reasons, whether one looks at the language of Clause 49 itself, or whether one looks at the scheme of the charter party and the other provisions, with the reference to charters or their agents throughout, then one can see that charters or their agents can be given entirely the normal construction of the word agents. That's not a narrow construction or a limited construction. It's simply what agent means, a person through whom another is acting, or a person through whose agency that person is acting. So it can be given a perfectly sensible meaning in accordance with agents stricto sensu, or agents in the good pal sense.
Yep.
My Lord, I'm now going to move on to my fourth heading,
Right.
which are commercial considerations.
Yes.
And I've already addressed the Court as to my starting point, that it's impermissible to start by assuming a notional division of risk or responsibility, which is rational or commercial, to use the words being used, when construing an off-hire arrest provision. My Lord, it's impermissible in general, and we've set out in our case a number of citations from cases which say you should not approach a clause in this way, which is dealing with risk allocation, assuming a notional risk allocation. See the Fjordas, the Bergesund, and the Captain Stephanos, they're referred to in our case. But, my Lord, it's particularly inappropriate, in a sense doubly impermissible in this case, where one knows that there is a spectrum of different risk allocation, from one end all on the owner to the other end all on the charterer, which the parties adjust by sliding a point along the scale by the language they use. How can one therefore say, well, one must assume that the parties are seeking to achieve a particular result? One can't. The only way one can test it is to look at the ordinary language the parties have used. And, my Lord, the commercial considerations were dealt with by the Court of Appeal, principally founded on the Doric pride.
Yes.
And I'll take your Lordship to where the Court of Appeal deals with commercial considerations generally, after taking the Court to the Doric pride. My Lord, the Doric pride was a linchpin of the Respondent's arguments at all stages below, as you can see from the award, the judgment of Mr. Justice Field and the judgment of the Court of Appeal. It was rather taken second stage, or second seat in the Respondent's case, but as it played a very important part in the Court of Appeal's reasoning, it's appropriate to look at what the case actually decides. Now, turn to that. It's at tab 10 of the authorities bundle.
Yep.
I think the dissenting arbitrator made the point which you're making.
My Lord, the dissenting arbitrator, unfortunately the late dissenting arbitrator, Captain Leftakis, died last week. We were sorry to learn. The dissenting arbitrator took effect with the Court of Appeal's approach, which was the Doric pride is not to be read narrowly, it's to be read very, very wide as setting out a sensible division of responsibility for arrest and off-hire clauses. It was the majority.
Sorry.
It was the majority
Yeah.
who took my point, my lord,
Yeah.
and said no, it is to be read as a case on its facts and its clause.
Yeah.
So, my lord, if one turns to Doric Pride at tab 10 in the authorities bundle, my lord, this concerned a vessel, a new build vessel, which was detained on her call at a US port. It was her first time in the United States. And there was heightened security after 9/11. There was a delay. My lord, the provision, if your lordship turns to page 190 in the report, 272 in the MS numbering, is at page little C and D.
Yes.
And your lordship sees that it's precisely like clause 49, except that on the end, after charters or their agents, the words "or by reason of cargo carried"
Yes.
or calling port of trading under this charter party. And then, as the court said, the issue is whether the detention of the vessel on her way to call at New Orleans for the purpose of loading a cargo, the detention being on the orders of the captain, should fall within the first half of the clause and therefore lead to the vessel being off hire, or within the proviso. Now, my lord, importantly at page 192, and I won't take your lordship to the clauses in detail, Lord Justice Ricks set out a number of other charter party provisions which dealt with the right of the charterer to trade the vessel and the obligations of the owners in relation to the vessel's requirements. And then, my lord, going on to page 195 in the report, 277 in the MS numbering, Lord Justice Ricks said this: for these purposes, one has to stand back and ask the question, what is the distinction which Clause 85 is seeking to make between the primary part of the clause and the proviso which it ends? What is that proviso concerned with? It is concerned essentially with two things. One is any personal act or omission or default of the charters of their agents, and the other is by reason of cargo carried or calling port of trading under this charter party. So just pausing there, my lord, Lord Justice Ricks was immediately at pains to point out that the clause was dealing with two different things. One, charters and their agents. Two, this wider expanded phrase. We are not here concerned with personal act, omission or default of the charters or their agents, but it is submitted by Mr. Cooper that this is a case of detention by reason of calling port of trading. It seems to me that when one looks at Clause 85, so now what he's talking about is this Clause 85 and this wording, in the context of the other clauses under this charter party to which I've referred in this judgment, that was at page 192, one sees that there is, within the express wording of the particular clauses, a basic distinction which the charter seeks to make, and which is entirely familiar to owners and charterers, between those matters which lie upon the owner's side of responsibility, essentially the vessel and crew, which the owners have to provide to the charterers, and those matters relating to the charterer's employment of the vessel and crew for their trading purposes, which lie on the other side of the line. Thus one has come across reference to cargoes carried or ports visited while vessel is employed under this charter party in Clause 2, and ports called or cargoes carried in Clause 84 as well. Those are the closest analogous expressions to the words which fall to be construed in Clause 85, but the point I seek to make is a more general point than that. In its various forms of wording, the Charter seeks to draw the line, which can often be a difficult line to draw in just a few words, between matters which are the owner's responsibility and matters which are the Chancellor's responsibility. It's possible to see this line being drawn in those clauses. And then, my Lord, the question, paragraph 35, is on which side of the line of either owner's responsibility or charter's responsibility do the facts of the case fall? And, my Lord, what Lord Justice Ricks was there dealing with was the specific argument of Mr. Cooper that this was a case of detention by reason of calling port of trading, and he was trying to analyse, in the light of that division, which side of the line that fell. And the court held that it was the side of the line to do with the vessel, not the side of the line to do with the calling at the particular port, and one sees that at paragraph 45 of the judgment. So, my Lord, in our submission one gets no assistance from the Doric Pride, and a very experienced tribunal, an arbitral tribunal, correctly and succinctly dealt with the relevance of the Doric Pride. If I can take you to the appendix in the core volume at page 151 in the MS numbering.
Sorry, what page?
Sorry, my Lord.
What page?
151, my Lord.
Thank you so much. Yep.
This is tab 6, is it?
It's the appendix, my Lord, in the core volume.
Paragraph 29.
Paragraph,
Is that right? Or what part?
paragraph 43, my Lord.
43.
Oh, wait a minute.
Yep.
Setting out the point which,
Yep.
was extracted, needs to be read in context from the Doric Pride as we just have. We did not find this distinction helpful in construing the words occasioned by any personal act of omission or default of the charge of the agents, since Lord Justice Ricks was drawing that distinction in order to construe the words by reason of cargo carried or calling port of trading under this charter in clause 85 of the charter which he was considering. Well, that was impeccable, and the error which the Court of Appeal made is precisely the same as the error that the late dissenting arbitrator made. If you turn on to page 156,
Yep.
paragraph 5, paragraph 46 of the reasons, the majority say that Doric Pride does not help. With respect, it seems to me the point Lord Justice Ricks does make is the very point which is at stake, and we are concerned with in this case. In my view, his comments are intended to be a wider application. And Lord, they weren't. Mr. Justice Field correctly rejected the argument that the Doric Pride was any assistance, and the Court of Appeal should have done so likewise. If we now turn to the Court of Appeal's judgment on this point at MS page 118 in the appendix, sorry, my Lord, I've got the wrong page number. 121. I do apologise. 121.
Thank you. Yep.
My Lord, it really comes, it's dealt with in paragraph 41,
Yes.
Doric Pride, and then Lord Justice Gross says this: as a matter of business common sense, the background to clause 49, including the proviso, is as expressed by Lord Justice Ricks in the Doric Pride. And he looks at the passage we've just looked at. My Lord, the background to clause 49, including the proviso, was not that set out by Lord Justice Ricks in the Doric Pride, because Lord Justice Ricks was considering a different portion of clause 49 which is not present in clause 49, namely the wider expansion wording by reason of cargo carried and ports called at. And so to apply that, my Lord, to clause 49 is precisely to make the error which cases have said should not be made of applying some generalist scheme to clause 49 or any other provision. But, my Lord, it's particularly inapposite in the case of clause 49 because Lord Justice Ricks was considering particular wording which isn't present in this clause. So, my Lord, where he goes on to say there can be no doubt in the present case that the action or default involved Cargill's delegates and fell on its side of the line. NYK was not involved in the apparent dispute between Transclear and IBG. Well, my Lord, nor was Cargill. While it is correct to say that Cargill was under no obligation to discharge, the dispute in question arose out of its trading arrangements concerning the vessel. It is simply misplaced, and then, unless therefore precluded by the wording of the clause, my Lord, which is a very odd way of going about it in our respectful submission, I would regard it as unsurprising if such events came within the carve-out, which he seems to mean some sort of generalised proviso, taking things out of the off-hire event. Accordingly, the commercial context powerfully reinforces my interim conclusion as to the true construction of the proviso. And, my Lord, that in our submission was wrong. My Lord, where the Court of Appeal went on to consider other commercial aspects in the judgment, one sees at paragraph 42, at the top of the second column on page 111, on the approach to which I am attracted, the acts or omissions of both Transclear and IBG lead to this result. While the starting point must be the construction of the clause in question, rather than any generalised assumption, the outcome is unsurprising and gives effect to the familiar division between owners and chartered spheres of responsibility. Well, my Lord, there isn't one in relation to arrests and off-hire, and what Lord Justice Gross was taking was a familiar division which was reflected in specific wording in the clause in the Doric Pride. My Lord, he then concludes on the Doric Pride in paragraph 43, little 1, at the bottom of that little subparagraph. So far as concerns the Doric Pride, I relied on it for the statement of principle cited above. It is neither here nor there that the particular clauses with which the court was there concerned are different to those under consideration here. My Lord, it was. Here and there, because those clauses specifically defined how Lord Justice Ricks arrived at the division of responsibility he did, because he found that the division of responsibility between trading and vessel were specifically reflected in the specific words of Clause 49. So the Court of Appeal was badly led astray in our submission by the Doric Pride and should have put it to one side, as the majority and Justice Field did. And although the Court of Appeal said that it wasn't approaching it by way of generalised assumption, one can see from the passages which I have taken the Court to read fairly, that the Court of Appeal was plainly very swayed by this division in the context of an arrest off-hire provision. Well, the only other aspects of commercial consideration which I need to take the Court to are dealt with earlier in the judgment at paragraph 40. And there are 2 points.
Yep.
My Lord, first, the Court of Appeal thought it was uncommercial to try to establish a correspondence between obligations under the different subcontracts and the charter party. But, my Lord, in our submission, there's no difficulty about doing that at all. The only difficulty was the approach that Mr. Justice Field took of trying to define the obligation under the charter party by reference to the obligations under the different contracts. That was not inherent in our argument. Our argument is that you simply look at the performance of the obligations under the charter party, and, my Lord, far from occasioning difficulty or being artificial, it's a job that arbitrators in the commercial court are doing regularly, as cases like the Mediolanum, the Good Pal, the Adelpha, the Andra, the Mozart, and others all establish. Was this act done by this person while he was performing an obligation of the charterer? Yes or no? There may be factual questions, but that is not an imprecise test. My Lord, what is an imprecise test is what the Court of Appeal goes on to comment on in paragraph 40, subparagraph 2, which we've looked at in a different context. And that is where the line is to be drawn on the Court of Appeals and the Respondent's construction. Because if one looks at what the Court of Appeal says in paragraph 40, subparagraph 2, of leaving it over for decision as to whether the act of some act of a Cargill delegate wholly extraneous or unrelated to subletting under the charter party or inconsistent with its scheme is wholly vague. And, my Lord, is an uncommercial approach to defining when somebody is or is not within the clause. It simply misses the far simpler point that agent, stricto sensu, or agent good pal, can be readily defined, and that's what the words mean. So, my Lord, that's all I wanted to say in relation to the commercial considerations, which plainly played a large part in the Court of Appeal's consideration. And I think, my Lord, I hope I haven't taken that too fast or done injustice to my case.
As I mentioned, you've sorry, I was just going to say, you like Mr. Young, you've set out your submissions in writing fairly fully, and the fact that you don't emphasise something that's in your written case doesn't mean we're treating you as abandoning it. Thank you, my Lord. My Lord, that then means that I can come on to issue 2. My Lord, issue 2 is the question of fact.
if the appellant's construction is correct, then were Transclear and IBG to be regarded as charterers agents under Clause 49, were they performing an obligation of Cargill as charterers under the Charter Party at the relevant time? Well, that is a question of fact, but it arises as a question of law for this court because of the owner's case and Mr. Justice Field's approach to performance of an obligation of the charterers under the Charter Party. The only relevant obligation which is in play is the obligation under Clause 8. No other obligation is relied upon by the respondents, or has been at any stage in the arbitration or thereafter. Clause 8 is an obligation to carry out the physical cargo handling operation involved in loading or discharge, as and when that takes place, and that alone could be the subject of any delegation de facto by the charterers. What I propose to do in relation to issue 2 is deal with matters under 3 headings. First, I will analyse briefly the relevant obligation under the Charter Party, so one defines the actual parameters of what that obligation are. Then I will consider the factual position as found by the arbitrators and see how that fits with that obligation. And lastly, I will consider Mr. Justice Field's approach of looking outside the Charter Party at the terms of the sale contract, and whether that is a correct approach. My Lord, my first heading then is the obligation on the charterer. My Lord, as we've seen in the good pal, it is the Charter Party obligation and its delegation to the third party which alone defines when the third party is acting as or on behalf of the charterer. My Lord, in the good pal, I won't take the court back to it, but I'll give the page references, page 642, page 643, Little Roman 5 and Little Roman 9. Mr. Justice Coleman defined the obligation of the clause as being the process, to carry out the process of loading or the process of discharging. And precisely the same approach is taken in the Jalaguri, which I need to take the court to, which is at tab 17 in the authorities bundle.
Right.
My Lord, I referred in an earlier context to the decision of Mr. Justice Ricks at tab 16, but we don't need to look at that for the purposes of the Clause 8 debate. My Lord, in this case, a vessel presented for discharge and started discharge. Unfortunately, some of the cargo was damaged, and the Port Authority stopped the discharge and required a guarantee to be put up for the costs of storing the damaged cargo. And that was a condition of the discharge operation continuing. The vessel waited until the owners eventually put up a guarantee and discharge recommenced. The charterers claimed that the vessel was off-hire due to detention, and the owners said it was due to the fault of the charterers in not putting up a guarantee to enable discharge to continue. So effectively the argument was, because you undertake the discharge, you also undertake to make sure you pay all the conditioned precedents of discharge, for example, satisfying the Port Authority and putting up its guarantee. That is part and parcel of the discharge obligation. And it was held by the Court of Appeal. It wasn't. But if I can ask your Lordship just to point up the clause, which is at page 702 in the report, 347 in the MS numbering. Clause 8 is in the middle there between F and G.
Yep.
It was a form that said charterers are to load, stow, trim, tally at both ends, secure and discharge all cargo at their expense. Our clause is rather shorter, though it's not said that any difference arises out of it. Our clause says, shall perform all cargo handling at their expense. My Lord, the issue we can find at the bottom of page 705. And Lord Justice Tuckey cites from Mr Justice Ricks of first instance, the issue therefore is, does the obligation to discharge render charterers in breach of Clause 8 merely because the authorities, it's the bottom of the page at 8,
Yes.
merely because the authorities make something which is not a matter of discharge into a condition precedent of permission to discharge? I do not think that Clause 8 has the far-reaching results which the owners contend. I agree that storage costs and removal costs of goods once those goods have been discharged are not costs of discharge. They do not therefore fall to be charterer's responsibility under Clause 8. And then over the page, my Lord, at 351, Lord Justice Tuckey says, the owners submit that the judge should have upheld their submission that as Clause 8 imposed the responsibility for discharge of the charterers, it was for them initially to meet all expenses necessary to effect discharge, which in this case included the provision of the security. And just pause there, my Lord, it could all similarly be argued to free the vessel from arrest or for receivers to pay the demurrage or satisfy the transclear claim. Mr Hill supported his arguments between B and C by pointing out that the Charter imposed no obligation on the owners relating to the discharge of cargo. This was consistent with the position at common law, where the owners were required merely to get the goods out of the ship's hold and put them on deck alongside. The starting point for consideration of these submissions is the language of the clause. The words used are apt to describe the physical acts involved in loading and unloading the cargo. In other words, the clause is concerned with the expenses involved in cargo handling. This is made clear in the 1993 revision of the NYPE form, which requires the charterers to perform all cargo handling, including, but not limited to, and they're then set out, but is, I think, also the natural meaning of the words in the 1946 form. Nothing in the wording of the clause suggests that it imposes a wider responsibility for ensuring that a third party does not prevent cargo handling from being performed, my Lord, opposite to our case. 2, the costs of storing or removing damaged cargo after it has been discharged are not costs of discharge. The clause is not wide enough to make them so simply because a third party has made security for their payment a condition precedent of discharge. And my Lord, one sees the relevance of that to the facts of the present case and the activities of Transclear and IBG. So, my Lord, what we are looking at in posing the question, which we say is the correct question to pose under Clause 49, are, at the time of the Act submissions, etc., relied upon by the owners, was either Transclear or IBG in the course of performing the Charter's discharge obligations under Clause 8. My Lord, in relation to Transclear, Transclear had nothing to do with the eventual discharge of the vessel. When it arrested the vessel in December 2008, she was in the arrival anchorage and never got into berth. Discharge did not in fact begin until January 2009, and therefore at no time did Transclear become the delegate of Cargill. And my Lord, there is in our submission an important finding of fact by the arbitrators, which was given effect to by Mr Justice Field, that there was no evidence before the arbitrators in support of a finding that Transclear was performing in any way Cargill's obligation to discharge the vessel. And I can pick that up, my Lord, in Mr Justice Field's judgment, rather than go to the award, because he refers to the relevant passage, which is in the appendix at page 132.
Yes.
And what Mr Justice Field said there was, in my judgment... Paragraph 20, my Lord, column 1 on page 460. In my judgment,
Yes.
Transclear's arrest of the cargo and by mistake the vessel was not enacted by Transclear as part of carrying out any responsibility delegated to it by Cargill, whilst the majority erred in rejecting NY claims based on Transclear having been Cargill's agent. They did not err in rejecting this claim on the ground that there was no evidence that Transclear was performing Cargill's obligation to discharge. And the relevant paragraph in the award, my Lord, just there, is paragraph 42, MS 151.
Thank you.
My Lord, all we know of Transclear is that it was a CFFO seller. Under the CFFO contract, it would have had no obligation to discharge. We don't actually know the terms of any contract above that which Transclear were party. We don't even know whether Transclear accepted an obligation to discharge at all, which is why the arbitrators found as they did. My Lord, in relation to IBG, IBG became Cargill's delegate or agent for the purposes of the Charter Party after the vessel put in for discharge and when she was discharged by IBG. Then and only then was IBG performing an obligation of the charterers, i.e. the carrying out of the cargo handling, the physical process of cargo handling. Once that obligation was complete, once the performance was complete, IBG ceased to be the agents, but IBG did not become the agents until they actually started it. And again, my Lord, one can test the position in the example of Transclear having intended to discharge through IBG, but because of IBG's problems and making difficulties about demurrage, Transclear diverting the cargo to another receiver. That was an entirely common state of affairs, and in those circumstances, anything that IBG was doing could not possibly be treated as an act on behalf of the charterers, because the charterers were not acting in any material sense through them or through the agency of IBG until IBG took on the discharge obligation and started doing it. So, my Lord, on the facts, we would submit that applying the test correctly, and it's really only the good pal test, to Transclear and IBG, there is no case for saying that Transclear and IBG, in relation to the acts which they carried out all before discharge and all unrelated to the actual carrying out of the discharge operation, could be regarded as in performance of the charter's obligations. They were therefore persons through whom the charterers were acting through the agency of. I only now need to deal with Mr. Justice Field's decision.
Would it be sensible to deal with that
think it would, my
after the
Lord.
adjournment? Also, you've, if I may say so, done very well in light of the fact that you only learned of our view on timing this morning. If there's any other point that you've passed over in order to complete by now, you must deal with it after you deal with it after the short adjournment. Thank you very much indeed. We'll adjourn now. Resume again at 2:00.